Today the topic is inheritance planning, and I'm very fortunate to be joined by Eden Mahar, a lawyer with LLF Lawyers, and Seaborn Gail Barker, a lawyer with Walkers LLP. Welcome.
Thank you.
Thank you.
Now, with three lawyers all together, there'll be a variety of opinions on these topics, but one thing that we'll all be agreed upon is the importance of having a will. We've all had people in our office where we've recommended it to them and they've been dismissive to say, oh, well, that'll be the kid's problem, I'll be 6 feet under and somebody else can worry about it. Seaborn, what do you say when people confront you with that enlightened thought?
Well, my first response is your family's going to hate you. That's all there is to it, because your estate will be an absolute mess and it's not going to go where you intend it to go.
Yeah.
So a will, as we all know, reflects an individual, that the testator, the person giving the instruction who owns the will, reflects their intentions and what they're going to do with everything they've acquired through their life, be it personal or physical assets or monetary assets. And I think if you've lived your life long enough and you've gathered these assets, you should take the time to decide where they're going to go at the end of your day. You can go without a will, but the government then gets involved, and I think the majority of people I've talked to does not want the government deciding where their assets are going to go.
There's a lot of terminology that can be confusing with people about wills, and I know people think they may have a power of attorney, they think they've got a will, and vice versa. What kind of terminology issues do you think that our viewers should be aware of?
Those are important ones. So a power of attorney is a document that's used during your lifetime where you appoint somebody to make decisions for you on your behalf, either that you don't want to or that you're not capable of making. What we're talking about today, though, are wills, and those are the documents that take effect after you pass away.
Right.
Some of the terminology can be quite confusing. Seaborn just mentioned testator, and so for those less familiar, the testator is the person giving their wishes in the will. Other terms, we've typically been using the term executor,
right,
or that's the male version, executrix, the female version of that word. In Ontario, we've gone the way of using the term estate trustee. These are interchangeable: executor, executrix, estate trustee.
Right.
And we use estate trustee because that executor is entrusted with your estate.
Right. And carrying out your wishes, and the only way in which you get to express those wishes in a legally meaningful manner is what?
In a will.
In the will.
That is done by a lawyer.
That's right. Telling people during your lifetime that this is what I want, or I want somebody to have my house when I'm gone, is just not a meaningful statement. Once you're dead and gone, if you don't have a will, as Seaborn mentioned, it will be the government in the form of legislation that decides who inherits and not you.